morning, Sir James.
Really good morning. I just had two final topics to deal with. The approach to the best interests of the children is first. And so far as that is concerned, a couple of points on the ECHR and international materials, just to make a couple of early points. The first is that although there is plenty of case law from Strasbourg indicating the importance that needs to be attached to the best interests of the child, the authorities in Strasbourg equally emphasise that those interests are not, as it were, as they put it, a trump card in the analysis. I'll give you one reference to that without needing to turn it up. I think we've seen the case before. It's El Gattet and Switzerland, tab 53. The relevant paragraph is paragraph 46 on page 1387.
Do they actually use that terminology?
I think they do in paragraph 46.
Yes, they do.
Yeah. Cannot be a trump card which requires the admission of all children to be better off living in the contracted estate. 1387. The second point in relation to the approach, it is a small point in relation to the UNCRC, to which you've seen various references. That's the United Nations Convention on the Rights of the Child. That, the short point is that is concerned, as appears from Article 2.1, tab 66, page 1754. So tab 66, 1754, Article 2.1, which says the state parties shall respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination. And that's the scope of the best interest duty on the same page, Article 3.1. So it's restricted by within their jurisdiction. I'll go back over the points that I made in relation to the ECHR in relation to that, but it's the same jurisdictional constraint in relation to that convention. And that's reflected in section 55 of the Borders, Citizenship and Immigration Act of 2009, tab 65, page 1749, which requires under sub 1A the Secretary of State to make arrangements.
So 1749.
1749, my lord, I'm sorry, yeah. Section 55 1A, Secretary of State must make arrangements to ensure the functions are discharged having regard to, quote, the need to safeguard and promote the welfare of children who are in the United Kingdom. You see the basic point. It's not children anywhere in the world. This is specific obligations to children who are in the United Kingdom within our jurisdiction.
So what do you say? There is no relevance of the fact that the children are suffering in a foreign country, or what?
My lord, we don't go as far as that, and we don't need to, because I emphasised, I hope correctly, that in the Strasbourg case law, the principle was not a trump card, but nevertheless an important consideration. So this is not a set of submissions that seeks to discount, under the Strasbourg jurisprudence, the best interests of the child, but that best interest is not, as it were, separately supported or amplified by either reference to the UNCRC or by reference to the domestic obligation transposing it in effect.
So where did the Upper Tribunal go wrong?
Well, my lord, can I come to that? I just wanted to sweep those 2 points out of the way first in relation to that. We do say that the Upper Tribunal should have acknowledged those points, that it wasn't a trump card, and that the UNCRC is concerned with duties to children within the jurisdiction. The same point applies in relation to section 55. We do not say they were not entitled to consider the best interest of the child. What we do, however, say, in relation to the Upper Tribunal's approach, is that they approached best interests on the basis that this opened up, whether because or separately from the point that they considered that the children themselves had Article 8 rights, but they approached the best interests issues on the basis that this opened up what was, in effect, an analysis as to how to remove the children from the risk caused by the situation in Gaza. And we submit, for reasons which I touched on yesterday, that that is the wrong approach. It is, in effect, if you do it that way, you just look at it at large, it is, in effect, to treat reunification or movement from Gaza to the United Kingdom as the remedy for what are, in effect, Article 2 or 3 concerns, in circumstances in which the UK has no responsibility for those conditions, no responsibility for the creation of those risks, and in which the Strasbourg case law is absolutely crystal clear in Khan, they are not within the United Kingdom's jurisdiction, so that there is no obligation to grant entry to the UK to protect them from those sorts of risks. And one can put the same point in a variety of different ways, but another way perhaps of putting a similar point is to say that the children's best interests do not, in the context of Article 8, where the children are out of the jurisdiction, ask, well, what generally might be in their best interests? But instead ask whether, by reason of their relationship with their uncle, brackets their family life for this purpose, their best interests require reunification. And viewed in that way, the only possible answer is that they did not. The core family unit remained. They remained with their mother and their father and their siblings. The connection to the uncle, for reasons I gave yesterday, was remote. And those risks are unconnected to the family life aspect. They are simply general humanitarian risks faced by all children in the war zone. One can take the examples out. Don't wish to create absurd examples in what is an evidently tragic situation in Gaza. But suppose, for the sake of argument, that you had a foreign jurisdiction in which children resided with their entire family unit, and they had very fast cars and no system of traffic controls at all, so that there were frequent risks to life and limb if you drove around the country. It's the same point. Those risks are of a general nature, affecting the general population in the area concerned. There is therefore a disconnect between family life and the use of family life to try to drag in, on the basis of a connection to other remote elements of the family, to try to drag in general elements of risks applicable to the entire population and turn that, in effect, because of the weight of the Article 2-3 considerations or equivalent, into some form of trump card. That's what we say about best interests of the children. The risk of death in Gaza, which is my fourth and remaining topic, deals with and leads to substantially the same points applying, I submit. The risk to death is not the responsibility of the UK. A child with no family connection to the UK couldn't mount an Article 2 claim for relocation to the UK. See Khan. Under Article 8, what is required is that there should be and must be a positive obligation on the state to admit/reunify based on the need to protect family life. And without the risks in Gaza, there'd be a straightforward answer to that question. There's nothing like sufficient in the relationship with the sponsor to call for that. And we submit that the humanitarian crisis and the risks of death in a war zone of a general kind cannot convert the case so as to introduce, in effect, a Trump proportionality card. That would be to introduce through the back door that which cannot be introduced through the front. And it would be to introduce circumstances which are not focused, as they must be under Article 8, on family life. And of course, family life can end for a variety of reasons. Death, inability to make the phone calls, inability to maintain contact because there is social separation caused by the physical or other circumstances in the state, inability to provide financial support or to visit, and so on. If the end of family life is relevant at all, it can only be in the most limited sense, where the risk of family life ending is something which the state doesn't control and isn't responsible for. In other words, a positive obligation to grant entry can never arise, we submit, merely because there's a serious risk of family life ending due to circumstances beyond the state's control. I'll put the same point in a slightly different way. The focus on family life requires, as it were, an assumption that there is family life to continue, which is going to be facilitated or protected by reunification or movement. Otherwise, it just becomes a remedy for removing you from an Article 2 or 3 equivalent situation. And ultimately, in any event, even if one assumes that there is some relevance to this, it has to be placed into the balance. It has to be placed into the balance with the existence and the nature of the family life, the nature and quality of that family life, and most importantly, the need to maintain effective immigration control and avoid placing unreasonable positive duties on the state, having particular regard to how many around the world might face such general risks. And so we do submit that to, as it were, take generally applicable risks which could not be directly relied upon and harness them to the Article 8 wagon so as to create, in effect, a trump card because of their seriousness is simply impermissible. That's how we put the best interests and risk to life points. My lords, my lady, those were my submissions in opening the appeal to you.
You're not going to share us any parts of the judgment of the UT?
My lord, what I'm going to try and do, and I'm sorry I haven't done it overnight, I started overnight and then I'm afraid got distracted on other matters, but I'm going to try and put on two sides of a bit of paper the core criticisms that I've made orally of the Upper Tribunal.
It's not the general criticisms.
No. These are the specific ones tying it to the paragraphs.
It's the lines in the decision that you say are wrong.
Yeah.
And as opposed to a balance that some other decision maker might have taken a different approach to.
Well, my lord, yes, and I've made my submissions on that, and I've made the criticisms. As I say, I will pull together. It's not going to be anything new. It will be what you've heard from me orally. And we'll
but it's the paragraph references I'm interested in.
Yes, well, that's what I'm afraid.
I'm interested in actually seeing where they went wrong, because otherwise it just looks like you say they attach too much weight to this and not enough weight to that.
Well, my lord, I hope my oral submissions have not been of that ilk.
Okay.
And I've identified what we submit
They
are
must have
errors.
made a mistake to get the wrong answer, right?
Errors of principle and approach are fundamental to this. But I'll try, if I may, to harness those submissions that I've made orally and then put the paragraph specifically to you.
Okay, thank you. Anything else for Sir James? No. Mr. Hussain.
My lords, my lady, thank you. Just on Sir James's last point, it really isn't acceptable because I'm supposed to be responding to his submissions at the moment. I don't know which paragraphs he criticises the Upper Tribunal's decision.
Well,
Mr.
I think you'll have to do your best. I think he's nailed his colours to the mast of an inappropriate balance and putting too much weight on the risk of death in Gaza, the children's best interests and welfare, and
but as you
not sufficiently evaluating the quality of the family life, if there was any.
But my lord, as you observed, without giving you any particulars of those errors by reference to paragraph numbers, but there it is. My lords, my lady, In his celebrated Cambridge lecture on the rule of law in 2006, Lord Bingham identified the duty of the executive to obey the law as part of his 6th sub-rule, and noted that in the past the convention was that ministers, however critical of a judicial decision, and exercising their right to appeal against it, or in the last resort legislate to reverse it retroactively, forbore from public disparagement of it. This convention appears to have worn a little thin in recent times. One wonders, we ask, what Lord Bingham would have made of the exchange between the leader of the opposition and the Prime Minister at PM's questions on the 12th of February this year, publicly disparaging the decision of the Upper Tribunal below, and doing it on a basis that was false, namely that the applicants had exploited a, quote, loophole in the Ukraine scheme in circumstances where the Upper Tribunal had in terms explained that they acknowledged they couldn't qualify under that route, had simply chosen that form in accordance with Home Office policy with regard to applications for entry clearance. That's paragraph 4, Upper Tribunal, page 88, for bundle. My lords, my lady, you will be aware of the circumstances in which this appeal came before you. You will be aware, following hostile media attention, the Secretary of State's position initially being that the case was very specific and does not set a precedent for other potential applicants, since the Upper Tribunal had ruled against the Secretary of State on the narrow facts of this case. 6 weeks late, the application for permission came before my Lord Justice Dingemans. My lords, my lady, you will also be aware that this case concerns a British citizen who did and continues to perform valuable work for the United Kingdom, who sponsored his brother, sister-in-law, their children in Gaza in what Sir James described as ghastly and evidently tragic conditions. My lords, my lady, publicly attacking the judges, misrepresenting to the public what they decided, appealing and deciding to argue that this was a case raising points of general principle, only following hostile media coverage in a case such as this, does not, we respectfully submit, show the government in its finest hour. It is not simply a kerfuffle. Ground 1. Thank you for indulging me. Ground 1, my lord, my lady. My lord, the Master of the Rolls deprecated the use of loose language and sought coherence in the case law. We respectfully agree and submit that the case law from Kugathas onwards is entirely coherent. The court should not sweep away 22 years of case law, still less given that, as we submit, you are bound to follow it by precedent, not simply Mobeen 47, but the case of AU, which...
Sorry, which case?
Not Mobeen.
Yes.
Not simply Mobeen.
So, not simply Mobeen.
No, simply Mobeen, paragraph 47, which you looked at yesterday, but also the case of AU, which Lady Justice Kerr, as she then was... Carr, I'm so sorry. Being confused with... you don't want me confused. Lady Justice Carr referred to that. The case was, in the law reports, is anonymised and is Udine at paragraph 40. I'll take you to that in due course, and I'll also address Biokubet. But given that Sir James says that Kumari is clear and consistent case law, and therefore does not, indeed cannot, mark a departure from the Strasbourg case law, but rather is simply explicatory or clarificatory of it, essentially Sir James is inviting you to depart from domestic authority because he disagrees with how it has interpreted Strasbourg. That is ambitious, to say the least, we say. My fundamental submission is that the test for whether family life exists between adults is not dependency, still less strict dependency in the true sense. to repeat my learned friend's phrase. Strasbourg has never said that from S and UK in 1984 onwards. The test is, words matter, loose language matters. The test is further elements of, quote unquote, dependency. That's the EST test. Or additional factors.
Sorry, just take it slowly. Test is further elements of dependency.
Yes.
And?
Or another formulation, quote, additional factors, close quotation, of dependency. That's the Bierski case.
Sorry, which case?
Bierski, you were taken to it.
Sorry, BST?
Bierski, the Polish case, Bierski, the poor
Bieski, sorry. You do need to really have clearly enunciated the cases you're relying on, because I'm not so familiar with them as you are.
It's my fault entirely.
Of course, I've got swirling round my head about 70 cases, many of which are entirely new to me, Mr. Hussain. So you have to take it slowly enough for me to be able to note it and understand what those cases really, really say.
My Lord, you were good enough to explain that yesterday, so
yes.
I will do my best to do that.
Please.
I'm sorry for not enunciating properly. But Bierski, it's the...
Bierski and Poland.
In Poland, the case
We
to
looked
which
at it yesterday.
Sir James took you, and that is paragraph 40, page 1582. So it's further elements of dependency or additional factors of dependency, and then quote, beyond normal emotional ties. Now, we say these qualifiers were conspicuously absent in Sir James's submissions. The question, the all-important question, as my Lord Marswold asked, is what does that phrase mean? And did Kugas's get it right, as everyone up to now has thought that they did? Or rather, I should say Lord Justice Sedley.
Well, I mean, I don't know this, but I would suggest that Kuthagass did not, or all the judges did not say the same thing in Kuthagass.
Subsequently, that's why, sorry, I should have...
You agree with that?
Ostensibly, they didn't. On analysis, we say that it's conspicuous that Lady Justice Arden does not disagree with Lord Justice Sedley.
Who does not? Brown.
Lord Justice Simon Brown doesn't say anything. Lady Justice Arden...
He said nothing in 3 paragraphs.
About, he discusses other issues about interference. Right. It's not worth getting
Lady Justice Arden.
Lady Justice Arden does not say, I disagree with Lord Justice Sedley. And so the challenge for me is to explain what she meant when she used the term dependency. I'll come on to that.
Okay.
But all the subsequent authorities proceed on the basis that Lord Justice Sedley got it right. And we say that Sir James's submission, that the phrase further elements of dependency or additional factors of dependency, that cannot mean full or complete or exclusive dependency for 3 key reasons. First, at the level of principle, Sir James's meaning is illogical. If dependency is understood as complete dependency, then there is nothing that can be added to it. What is the factor or element that is further to complete the dependency that the court is looking for? The use of the term elements or factors suggests strongly, we say, a broad rather than a narrow or reductive concept of dependency. Second, Strasbourg has said in terms that the test is not full or complete, or in their term, exclusive dependency. That is the Alvarado case, the case that was handed down after Kumari by the same third section at paragraph 49. Now that presents a further problem for Sir James's case.
So do you mind if we just look at that?
No, my lord.
Obviously the most, I think it's the most recent case.
It's a penultimate.
Penultimate 62,
Yes.
you say paragraph 49.
Yes, I think
As
there's
it
one
cannot be derived from the above-mentioned case law, as the authorities seem to assume that exclusive dependency is always required
Yes.
in order to find that family life exists.
Yes.
What does exclusive dependency mean?
It means that you are totally dependent on the applicant, or completely dependent, or, to use the phrase which Sir James majored on in his opening and his closing, and alighted on in the case law, that there is incapacitation leading to a compulsion to rely upon the sponsor in the applicant's daily life. You recall that the phrase in daily life was an important one. Your lordship made that observation, but that's his test.
Don't we have to see the statement in paragraph 49 of Alvarado in the context of the facts of that case, which was, I think there were 4 sisters in the Netherlands who were looking after this,
Yes.
the applicant who had serious disabilities, and he had a brother in Peru.
Yes.
But isn't that the context? Because he was
Well, it would be
significantly dependent on the sisters in the Netherlands.
Well, the moment you use the qualifier significant, that is a step away from the test which Sir James was relying upon you.
Yes,
because
but
significant dependence. Sorry, my lady.
It's nowhere near what we're looking at on the facts of this case. I mean,
Well,
you've got to look at the facts of each of these cases, not just.
My lady, I'm addressing the court on issues of principle at the moment.
Right. Okay.
I will come to the relevance of facts in a moment.
All right.
But the moment you introduce the qualifier, my lady, of significant dependency, then that's already a step away from the strict, true dependency for which Sir James contends. But all I need to show is there is a lack of clarity here. The jurisprudence, if on Sir James's view of it, isn't clear. You yourself, my lady, have just said, look, could it be a case of significant dependency? Well, that's not Sir James's case. I'll come on to the factual differences in a moment. Not in a moment, in due course, if I may. And we say that is what Lord Justice Sedley was driving at, that there's no test of full, complete or exclusive dependency in paragraph 17. We say paragraph 17 is correct. And it is what later cases which deprecate exceptional dependency are, we say, driving at and are inconsistent with. So that's Lord Justice Ryder, as he then was, in the AAU or Udine case at paragraph 40. And I'm going to do a trawl through, as you foreshadowed yesterday, through the key cases. These are just headline points.
Well, you've now got a third. You were going to say there were 3 good reasons.
The third point, the third reason, is my Lord's observation. Real and committed support and effective, real, committed, effective support, and further elements of additional factors of dependency over and above normal emotional ties are, as my Lord said, two sides of the same coin. Dependency is a relational concept. That explains why numerous judges of this court have either applied both tests, that's the "we are confused" category, that's Sir James's judges of this court are confused, if you remember. That's his second category. That's why they've applied both tests. Or they've simply applied the real and committed and effective support test. Lord Justice Ryder, Lady Justice Carr. It is an ambitious submission that multiple judges of this court have been confused over the last 2 decades when they apply real and committed support and dependency.
Well, I know you're going to deal with it, but Sir James's point is that from Kumari, you see clear examples
Yes.
of what is and is not family life.
Yes.
And this gives, even if it wasn't quite clear what all these, if I may respectfully suggest, thoroughly confusing terminology actually means, the examples tell you what they mean, and that if we could get away from labels and come to substance,
Yes.
he says it's clear from Kumari what it means. That's what I think you've got to tackle.
Yes.
I know you will.
I'll do my best. The fourth point I was going to make.
No,
those
you've
are
got
three
four.
reasons. Those are 3 reasons.
Yeah, okay.
Right, but my last point, by way of introduction, is that the domestic case law is consistent with Strasbourg principle, and that this touches on the point my Lord just put to me, is that the exchange between my Lord and Sir James on this issue was illuminating, if I may say so, because Sir James accepted that the dispute is about, quote, questions of degree rather than principle. Strasbourg has never qualified the degree of dependency required. It has never said true, strict dependency at the level of principle. It hasn't even said significant dependency at the level of principle. It has not said exceptional dependency at the level of principle. You know that it said further elements of dependency beyond normal emotional ties are required. So what we say is that the issue under ground 1 concerns the application of principle to facts. And there's no error of law in the FTT's decision, not least because the Secretary of State did not challenge Kugathas, indeed relied on it. And that is supplementary bundle, tab 2, page 26, paragraphs 32 to 33, where Kugathas Lord Justice Sedley is cited, and other cases are cited, including a case called Gizing, which I'll come to in a moment.
Well, we're a bit beyond whether they challenged it or not, aren't we? We have to
No, of
decide
course.
in a
No.
hugely significant appeal whether or not what Kugathas actually meant and whether it's been followed in.
I was simply addressing the concern that the court had when it was saying, look at what the FTT did. Look at, I think your Lordship asked, did the Upper Tribunal have Kumari before it? And it's important to see how the points were put. They were not put on the basis that this displaces the test.
Yeah.
And the other point I would make is these are examples. They're examples of the application of a test which is a stable test and which the domestic courts have interpreted and which in any event is binding. Now, those are my introductory points. can I then please go to two cases, Kugathas first and Singh. I'm going to do it in chronological order, if I may, and then take you to 6 cases before I get to Mobi. So that's, I'm going to look at 9 cases in total.
But you're mixing up, I mean, I'm not complaining if you are, but I just want to know, are you mixing up Strasbourg cases?
No, domestic.
Oh, these are all 9 domestic cases?
All domestic.
Yeah.
Yes.
I mean, you'll be aware that what Sir James has submitted is that even if he's wrong about Kugathas, the Strasbourg jurisprudence has moved on, and that we should be confident that Strasbourg would be content with the rule we're applying effectively.
Well, I mean, before I start, if you like, I can make submissions on AB. The short, and I can take you to AB. The short submission is that the fully confident test is about principle. It's not about facts. You don't hypothetically ask, are we fully confident that Strasbourg would decide a factual case in the way we are deciding it?
I don't think he said anything different from that. It's about principle, not fact.
Yes. Okay. Well,
I mean, he'll tell me in reply if I'm wrong about that.
Sir James has 2 problems. Either Kugathas hasn't changed the law, and that's his position actually. Sorry, what did I say?
Kugathas,
Kumari, sorry. Kumari hasn't changed the law. Under questioning from my lord, that is the position he arrived at. You can see why he needs that, because that is what gives him, he says, clear and consistent jurisprudence. So it hasn't changed the law. So everybody got it wrong.
Well, he's entitled to have
He
an
can
alternative
have
position.
2 alternative legal submissions. Of course he can.
Yeah, he can say it doesn't change the law, but if it did, then we should follow it.
Yes, the problem with that is the case the following month says no exclusive dependency as the test. And then
But
you've
as
got,
my lady points out, I mean, it is important with these cases to understand the facts.
yes,
Because as was clear, I think, many years ago, hard cases make bad law. I know that's in a private law context, but I fear it may also be the same in a public law context. So you have to look at the facts that the case was deciding before you draw principles from it, which are so general as to be applicable elsewhere.
my lord, of course, but the court actually says in terms there is no test. I don't have to do any drawing.
Sorry, there is no...
There is no test of exclusive dependency. It says that in terms.
This is in Alvarado.
Alvarado, paragraph 49, it says it in terms. So there's no...
Well, no test of exclusive, but exclusive is another word.
Oh, I see.
Which is not really presaged in...
Okay. Okay, assume that against me. Assume that against me. I say the point's good, it's not clear. If I can throw doubt on the new dawn, heralded by Kumari, then that's an issue for reception of the Strasbourg, the new Strasbourg jurisprudence.
What,
In the alternative.
what I would want to do
Yes.
as a, jobbing Court of Appeal judge is to look at the authorities and try and work out what they meant for the legal test. In other words, from how cases were decided, I mean, one of the points I think you have to deal with is that I'm not sure there have been many cases with facts like this, where family life has been established and the proportionality test has gone the way it did.
Yes.
And so that sort of lights a few red lanterns
Sure.
to consider whether the tribunal was applying the right test, based not any criticism of them, because although they had a lot of authority, I'm sure they had nothing like the authority or the firepower that has been deployed in this court. So we just need to examine the cases one by one to see in the context of their facts what they show the test to be in substance, because I find, but I am just what I said, I find the language used loose and confusing. So we need to look at what in substance they're really talking about by looking at what they decided, because that's actually the process we follow in these courts.
Yes, I immediately accept that the cases which where the court finds against the applicants that are surveyed in Kamari look harsh. They look stronger cases than ours.
Right.
But that's not an answer. That's not the issue.
Well,
You can have different.
it's one point.
Yes, it's certainly not the determinative point. You can, of course, have it's absolutely basic, particularly where there's intense fact sensitivity. You could have a legitimate difference of view as to what constitutes a fact, and it's a question of fact, and what doesn't apply to test. It's really basic. And we say that the job of the domestic court is not, to quote Sir Andrew Morritt in an early case, an ecclesiastical case, Aston Cantlow, the job of the domestic court is not to scrabble around in the European human rights reports looking for factual clues. Rather, he said, very old case, he said the job is to draw out the animating principles.
Now you're talking about a real judge.
Indeed, yes, that's why indeed. So I mean, that's my submission, that factual, pointing to cases which went the other way does not give you an error of law or wrong. In fact, we are in TCEA territory, so it's error.
No, okay, I only threw that out because I didn't want you to just go to paragraph 41 in this case and 23 in the other case.
No, I'm going to take you through them.
Without being clear. Well, we don't have to go through every inch of it, but we do have to understand what the facts were. That was my lady's point. It's very important.
Yes, I accept that the facts in those cases that lose, that are summarised in as examples, underscore examples please, appear harsh. And they are stronger cases that lose than ours on the face of it. The huge curveball, of course, is the atrocious conditions in Gaza and the legal relevance of those, both in the context of family life and the intensification of ties, and also proportionality. And we'll come on to that.
Okay, of course proportionality in one sense,
Yes.
but in family life,
Right.
Does that affect whether or not there is family life?
Yes, yes. I could give you...
In the sense that the relationship has formed because of those conditions.
Yeah, so I can give you... I can give you an example which I was toying with giving you before, but I'm going to give it to you. It's the grandmother example. So, or my sister. I can have a normal dependency with my sister. I depend on her emotionally, and she depends on me. When I have normal emotional ties with her, I see her every week or so. That's the phrasing, normal emotional ties, neutral perspective, not support, not dependency. That's clearly not enough. My Lord's grandmother example. You see your grandmother every Sunday.
I go and see on Sunday at 2:30.
There you go. Well, she's emotional. I'm very much looking forward to it. She's emotionally dependent on seeing you, and you are on her. But then, heaven forfend, there is a dramatic, transformative event which intensifies my emotional links with my sister, yours with your grandmother, and leads me to providing real, committed, effective support, whether by way of intense care or what have you. That creates on her side a, quote, further element of dependency above normal emotional ties, those ties are intensified. I may represent her only hope in escaping a very difficult situation. So Gaza is transformative.
But the major catastrophic event could be anything. I mean, it could be everybody else in the family being killed in a car
Oh,
crash.
absolutely.
Or, you know, something more parochial than the Gaza situation.
The focus is on the family life that is presented to the court or the decision maker.
Yeah, okay, thank you.
Can I just take you to one paragraph because the exchange is very helpful, from the case of E.M. Lebanon. It's House of Lords, or is it Supreme Court? I can't remember. No, it's House of Lords. So this is Lord Bingham. E.M. Lebanon. The facts aren't important. I can give them to you if you want. I know my Lord wants to contextualise statements of principle.
No, but if it's not important...
they're really not important.
Okay, where's the tab?
It's tab 7, page 107.
Thank you.
And the paragraph, the very, very well-known paragraph, is 37 at page 128. Families differ widely in their composition, in the mutual relations which exist between families, and marked changes are likely to occur over time within the same family. There is no predetermined model of family or family life to which Article 8 must be applied. The article requires respect to be shown for the right to such family life as is or may be enjoyed by the particular applicants before the court, and so on. And then the last sentence, in this context, as in most convention contexts, the facts of the particular case are crucial. Lord Bingham had said the previous year, you don't have it, in the very, very well-known case of Huang, that the role...
Platt.
Huang.
Oh, Wang, yeah.
Huang.
I know Wang.
I'm sure you do, my lord. It's an important public law case.
Yeah.
But he had said, paragraph...
That wouldn't mean I'd know it, Mr. Hussein, but
No.
I happen to.
It's a...
Yeah, he said in Wang.
He said that the role of oral evidence in this context and the impression that the sponsor in these cases makes on the tribunal is of crucial importance. And indeed, that was a point which the Strasbourg court also made. It said that the domestic courts are advantaged because they could often hear evidence. It was a passage from...
Can you tell me which paragraph of Wang it's in?
Paragraph 15.
15.
1-5. Yeah.
Yes, okay, you don't need to look at it, but I just wanted it for my note. Thank you.
Yep. And it, similarly, the Strasbourg equivalent of that, if you like, is in a passage to which Sir James took you at my request. It's in the last case in your bundle, Dimici v. Hungary, tab 63, page 1728, at paragraph 73, page 1742. The domestic courts, middle of the paragraph, are better placed to examine the issue before them and to ascertain the facts of the case as they have the benefit of hearing the parties in person and examining the evidence. Strasbourg is, of course, a supranational court. Subsidiarity applies.
But the court there was dealing with the particular factual issue in that case, which was whether or not two people had been cohabiting. That's the
if
context
my
of that
lady,
observation.
if my lady is putting to me that principle that domestic courts are better placed than the Strasbourg court when they hear evidence and examine the evidence, if my lady is putting to me that principle is restricted to the facts of the Demirci case, I would respectfully disagree. And if authority were needed for that disagreement, you have it in Huang, Lord Bingham, at paragraph 15. With respect, it's an obvious proposition that the court which hears evidence is advantaged.
Yes, but that's on factual issues.
Yes.
Rather than issues of principle
Yes.
or issues of assessment. That's the
No,
end
no,
point.
no. On issues of assessment as well and evaluation, of course they are. That's the point that Lord Bingham made. We probably should get Huang in a moment. That's important. Yes, Mr. Fakori reminds me, civil cases, Lord Hoffman, in the Mikulowski decision. That's very basic. And our point, you know, is the test is that the tribunals here got the test right, the domestic courts got the test right, and the question is how that should be applied, and the fact that the appellate court might think, well, it's a generous application, is neither here nor there, provided it's free from legal error. And Sir James does not advance a perversity analysis under ground one. He simply says that the lower court, the tribunal, First Tier Tribunal, got the tests wrong. The issue is, what's the test, not the application? Your lordships, ladyship, are not a first instance court, to state the obvious.
We know that.
Well, I'm going to make some submissions on the Tribunal in due course on the ground 3.
I've forgotten when I used to be at First Instance.
Yeah, I'm sure you have.
Okay, can you
So-
go through these cases?
Okay,
Because I
please.
think it's really important
Yes.
that you take the time to do so, and I don't want to take you out of your course so that you
Right.
find yourself pushed for time.
Yes. So, Kugathas, first of all, please.
Yeah.
And this is tab 2. You've seen it. It's an unusual case because the relevant family life sought to be protected merely comprised visits and telephone calls. That wasn't the starting point. That was the end point. Mr. Kugathas was in the UK and he was saying, it's more convenient for me to be in the UK and have visits from my family in Germany and call them than it would be from Sri Lanka. And the adjudicator had concluded, perhaps, well, clearly over-generously, that because of the increased expense of calls from Sri Lanka, there was a disproportionate interference. So, but that reduced family life in the UK had been created by a volitional act of Mr. Kugathas. So that factual background, contrary to Sir James's submission, does not give you a pointer here. Here, you might think the family life is weak, but if or it's not as strong as it could be, the tribunal went out of its way to say it could have been stronger. But that is because of objective considerations. They had evidence before them about how difficult it is to get out of Gaza and how difficult it is, particularly for the sponsor, with his profile, to get into Gaza.
Is it right that, I'm just checking on something, is it right that this family has not in fact left Gaza yet?
They haven't. There have been proceedings, your Lordship will be aware of, that I think Mr. Justice Chamberlain heard a case in July, and there are currently issues about exit routes.
Issues about
Exit, how they get out.
Exit route.
Yes. Yeah. Would you like more detail?
It's relevant, obviously, for the continuing anonymity issues.
Yes. I can give you more detail about it if you'd like.
That we got detail in Mr. Justice Chamberlain's judgment anyway. That takes us to June.
Yeah, things have moved on. I've taken instructions, but I don't think it's relevant.
All I wanted to know is
They
whether
are there.
they had in fact
No.
left Gaza, and the answer is no.
No, they haven't.
Thank you.
So you've seen paragraph 14, proper approach. Paragraph 17, Mr. Gill, Queen's Counsel, says none of this amounts to an absolute requirement of dependency. That is, if I may say so with some loose phrasing, I think what is meant there is no requirement of absolute dependency. Because you've got to have some elements of further dependency. Sorry, but I'm using language loosely there. Further elements of dependency.
Sorry. Which bit are you referring to?
Okay, I'm looking at paragraph 17.
70.
17.
Yeah.
So, and this is important because Sir James says this is where it goes wrong. So, Lord Justice Selly records a submission. None of this amounts to an absolute requirement of dependency. I'm suggesting that better phrasing, with very great respect to somebody whose English language skills are through the roof, if I may say so, Lord Justice Sedley, that is, you should have said that none of this amounts to a requirement of absolute dependency. And he says that's right in the economic sense, and then the passages that you're familiar with. But he can't mean that there's no requirement of any kind of dependency. He's just said that the UK is the correct approach, further elements of dependency. That's what he's reading, interpreting in light of Strasbourg case law, Marx in Belgium, real and normal, Abdelaziz, committed relationship, Beljudi, real and effective family ties. And then Lady Justice Arden, obviously important
Well,
to...
I mean, the problem with real or committed or effective support
Yes.
is that it can be real support or committed support or effective support.
Yes.
So they all mean different things. If it was
Well,
real, committed and effective support,
Yeah.
you might at least be able to interpret it fairly clearly.
Yeah.
Is that the test?
That is the test. And
That's the law, real or committed
or effective. That is. And this court has deprecated attempts to read that too strictly. And my submission is that you don't take the words in isolation. You interpret them justum generis. You interpret them in the context of S. I entirely accept that this is a gloss on S, but it is a gloss which the courts for 20 years have had no trouble with.
Okay.
And then the Lady Justice Arden, over the page, at paragraph 25, she says, because there's no presumption of family life, she must mean in that context, because it's obvious that parents of a child and partners to a marriage actually do have a presumptive family life. But in that context, there's no presumption of family life. In my judgment, it isn't established between adult child, surviving parent, unless something more exists than normal emotional ties. Well, we know that. Such ties might exist if the appellant were dependent on his family or vice versa. And then, and that's the sentence which Sir James suggests means that she's effectively disagreeing with or not agreeing with. Paragraph 17. Our submission there is all that she's doing is using dependency as a shorthand to mean further elements of dependency, that is the S case that she's just cited in the previous clause, not even the previous sentence, the previous clause. She's just cited S. S does not say dependency. It says further elements of. So we submit that dependent there, the word dependent, means further element of dependency, or it could mean Sir James's view, full dependency, as an example. But we say the former reading is the more natural reading because she's just cited S. She's not saying, well, I think S is too lax. Further elements of the... I've given you the submission about how, as a matter of logic, if dependency means total dependency, what are you adding? What are you looking for that's further to it? So that's Tugathas. Next tab, Pawandeep Singh. Now, this is not an adult relatives case, but I hope you'll see why I take you to it. One reason for taking you to it is that in one of the very key paragraphs in this appeal, paragraph 47 of Mobeen, Lady Justice Carr, she then was, I'm going to stop saying that every time I mention her, Lady Justice Carr applies paragraph 20 of Lord Justice Dyson in this case. So the issue in this case was whether adoptive parents and a child, where the adoption was valid according to local law, the Lex Loci Celebrationis in India, gave rise to family life when it was not recognised in UK law. The main judgments are from Lord Justice Dyson and Mr. Justice Mundy, as he then was a judge with, of course, very great experience in this field. Can I just take you straight away to paragraph 20 of Lord Justice Dyson? That's at page 42. And this is the paragraph to which Lady Justice Carr refers in Mobeen. Core principle, I believe, was stated by the European Court in Nebink and the Netherlands, the existence or non-existence of family life for the purposes of Article 8, essentially a question of fact, depending upon the real existence in practice of close first-law ties. That's important because it suggests there's a theme here across the case law. This is, Lebik was the case about access to, between a father and daughter. So I completely accept it's a nuclear family case, but the question is, are you applying a dramatically different test when it comes to adult relatives, or something more demanding but not radically different? And then at paragraph 29, actually it's because it's more, I can do it more quickly if I just take you please to paragraph 38, where Lord Justice Dyson said, would you mind casting your eye over paragraph 38? So this is important because where you've got family life, the decision maker also needs to consider the potential relationship that might have developed, and indeed the Upper Tribunal did that. I next want to go to Mr. Justice Munby, and this is at paragraph.
Sorry, just before you leave,
Yes.
Lord Justice Bryson, so where do you say he sets out the relevant principle? Which paragraph?
Paragraph 20.
It's 20.
Yeah.
Well, that's a completely different formulation. Real existence in practice
But
of close personal ties.
That is different because it's taken from a case which is about father and daughter. So it's the core unit. I can entirely accept that. The reason I'm taking you to it is because Lady Justice Carr refers explicitly to this, and it's part of my submission that it tends against the idea that you've got one test for the nuclear family and something dramatically different for non-nuclear.
Okay.
And the Upper Tribunal, sorry, I was on paragraph 38, and the Upper Tribunal, so this is about potential family life, this is something that the Tribunal looked at paragraph, just for your note, paragraph 171, page 129 of the core bundle. Mr. Justice Munby, next please, if I may. His judgment begins at paragraph 56. He says the issue is of great importance. At paragraph 57, he says, there's no shirking the fact, however narrow and technical the question we ultimately to decide, the case before us cannot be viewed in isolation from its particular social, cultural, and religious setting. The tribunals below had before them an expert report about Palestinian cultural mores, which said, inter alia, there was a cultural driver, indeed an obligation, on the sponsor to look after his family in these situations. And were he not to do that, it would, quote, be akin to a father failing his children. So that was expert evidence. You find it, it's supplementary bundle, pages 168 to 170. The First Tier Tribunal acknowledged that in its decision at paragraph 35 of its decision. Mr. Justice Munby at 63, a very, very, if I may say so, very rich and deep judgment, which I would invite my lady to read. 63, having surveyed various matters, he says the result of all this, in our multicultural and pluralistic society, the family takes many forms. This is redolent of the passage I showed you from Lord Bingham in E.M. Lebanon that was to come some years later, I think 4 years later. And then at 67, if I may, and this echoes something my Lord said, my Lord the Master of Rolls. He said yesterday that one doesn't want to be callous, one has the, strives to have the Kantian moral imperative of concern for others. 67, refer to the increasing religious diversity of our society. My third point, we live or strive to live in a tolerant society, increasingly alive to the need to guard against the tyranny which majority opinion may impose on those who, for whatever reason, comprise a weak or voiceless minority. Equality under the law, human rights, protection of minorities have to be more than the incantations of legal rhetoric. It's relevant to the numbers point. I'll come back to that in round 3. And at paragraph 79, he also refers to that passage in Lebing. And Lord Justice Chadwick, at the end of the report, paragraph 93, refers to both, sounding a note of caution about jurisdiction, interestingly. That's all I want to sing for. I now want to move on to the more relevant authorities. And the first is Bierke-Betz. We say this case is absolutely not authority for the idea that you need strict, true dependency. Dependency is dependency, as Sir James puts it, rather than further elements of dependency. Because you see the passage I invited him to show you, he was very accommodating as ever, paragraph 12 of the adjudicator's findings, page 98 to 99. Adjudicator said, families close-knit, interacts on a very regular basis. Appellant has a strong relationship with sisters. Currently resides with his mother and younger sister, travelling home most weekends during university time. Appellant also has a range of cousins and uncles in the UK. As for the suggestion that the appellant's mother relied upon him for emotional support, this he found entirely natural in the circumstances of the family departure. And so forth. Lord Justice Brown, in the passage to which Sir James took you, says this. Paragraph 39, 105, paragraph 39, second sentence, the dependency between the appellant and his mother here clearly engages Article 8, citing Macrani, additional elements of dependence, same idea, on the adjudicator's findings of fact, such additional elements of dependence can properly be said to exist in the present case. And I can make my first point, mutatis mutandis, to this formulation and say that if dependence really means strict, true dependence, incapacitation, medical conditions, and you're in the foothills, as my Lord Lunford put it, incapacitation giving rise to a compulsion to rely on the individual. This case is miles away from that on the adjudicator's findings and does not apply a dependency, strict dependency test. It says additional elements of dependence can be said to exist. So that key route out of stare decisis is blocked, we respectfully submit, for Sir James, because our submission is that it's the two sides of the same coin. My Lord's observation yesterday. Additional elements of dependency is the other side of the real committed effective support construed justum generis and in context. So that's Bierke-Betz. Can I next take you to ZB? This is at tab 9. So this is Lord Justice Aikins, Lord Justice Wall, Lord Justice Ricks agreeing with him. And Sir James says, I think he took you to certain paragraphs here. Sir James says this is fine because this is the Lady Justice Arden side of the line. This is Lady Justice Arden, not Lord Justice Chedley and Kogathas, so we're fine.
Do you mind giving the page number?
I'm so sorry, my lord. It is 158.
Thank you.
Paragraph 1. What's the correct approach when someone who's a parent and grandparent claims that she's dependent on a daughter and her family in the UK because of her ill health, no jurisprudence on this precise issue, or sorry, is limited. He says it's limited. Obviously, this is before AB is the law, but you won't find, are we fully confident in our conclusion. In this case, they find that family life potentially could exist. They don't ask that hypothetical question of future factual precedent. Would the Strasbourg court find family life in this case? You were taken to the facts outlined at paragraphs 3 to 4. The first tribunal, the lower tribunal, is outlined at paragraph 9. You were taken to that yesterday. Then the equivalent of the upper tribunal, it's called the Asylum and Immigration Tribunal. Here, an appeal and make findings. And then I can skip the pages. Mr. James referred you to paragraph 23 here, and also, I think, paragraph 33, the S case. And then paragraph 34, Hugathas, well, Justice Sedley described the decision of the Commission as now elderly, but he held that its principles were still correct. No suggestion that there was this sea of difference between Lord Justice Sedley and Lady Justice Arden when Lady Justice Arden is quoted. And then the case of Advich is quoted at paragraph 38. This is a Commission inadmissibility decision where, just from 38, if you could just read that briefly. So, the applicant sought entry clearance to join an adult brother and 2 adult sons. The parent-adult-child relationship in the familiar phraseology will not necessarily acquire protection of Article 8 without evidence of further elements of dependency involving more than the normal emotional ties. And then there's an analysis, paragraph 40 onwards, and the AIT's approach to family life is overturned. At paragraph 41, Lord Justice Aiken says the issue is fact sensitive. You've got to look at the group as a whole. It's multifactorial. And at paragraph 42, so this is why Sir James says this is all okay, because the word dependent is used. Some parent-adult children, something more than normal emotional ties between them has been shown, focuses on the parent. The issue must be how dependent is the older relative. Court isn't finding facts indisputable that the appellant is an insulin-dependent diabetic who needs to be cared for, either wholly or largely dependent on her family in the UK. So not exclusively, not totally, not strictly, not incapacitated, not the care isn't every day in daily life, or anything like that. And the principle that's being applied is S in UK and Hugathas, albeit it's Lady Justice Arden that's cited, but without having referred to Lord Justice Sedley. This, we say, supports my submission that Lady Justice Arden was not dissenting from Lord Justice said, you would expect a judge, this court, to say that, if they were. And it's really, dependency has got to be understood in that, in the sense of SCUK, further elements dependency, not strict dependency. The next case I wanted to take you to, please, is Patel. It's a case far removed from ours, so I'm not going to dwell on the facts, if you'd forgive me. It's about historical wrong cases where historically there were legal wrongs visited on individuals. This was about an applicant who recently secured British nationality, which had wrongly been taken away from her by the Commonwealth Immigration Act 1968. That, the provision which gave rise to the very famous case in the Commission, East African Asians, race discriminatory, for context. All I need to show you is paragraph 14, if I may.
Paragraph
14, page 187. You can set out to compensate for historical wrong. You can't reverse the passage of time. Many of these children have grown up, embarked on lives of their own. What's happened, the bonds which constitute family life will no longer be there. Article 8 won't have any purchase, but what may constitute an extant family life falls well short of what constitutes dependency, and a good many adult children, including children on whom parents themselves are reliant, may still have a family life, and so forth. So, he means, I respectfully submit, short of strict total dependency, and we see from the end of the report, page 191, 192, Lord Justices Longmore and Aikins, Lord Justice Aikins, who'd given the judgment in the ZB case, agreed with him. Next case I wanted to take you to, please, I want to spend a bit more time on this, if I may, is PT Sri Lanka. This is at tab 18. So this is Lord Justice Underhill with Lord Justice Beatson and Mr. Justice Cranston agreeing with him. It concerns a left-behind son. So this is one of Sir James's confused cases. He says they're confused here between real, committed, effective support and dependency. So the appellant, paragraph 1 to 4 summarises the facts. This left behind child in Sri Lanka, everybody else comes here. The First Tier Tribunal decision is summarised at paragraph 11 onwards. And the tribunal, you'll see, sorry, the First Tier Tribunal at paragraph 16 directs himself along the lines of 16, the bottom of 409, page 409. No evidence to suggest this relationship would require the protection of Article 8 without evidence of further elements of dependency, that usual formulation. Lord Justice Underhill at 17 says that the reasoning is distinctly compressed. Then, from paragraph 22 onwards, at 412, there is a sideline passage which we respectfully submit is very important. Could I ask you please just to cast your eyes over that? The 22.
Sorry, where are we stopping?
Oh, please, sorry, at the end of the sideline passage. It's quite a 26, if I may.
Oh, right, all the way down
Yes.
there.
Would you let me know when you've finished reading?
Yes, I've
Right, so
finished
8
it,
points.
But it's sort of,
Yeah.
yeah.
Well, this is eight
8 points.
8 points. First point, paragraph 22. Leading judgment given by Lord Justice Sedley.
Sorry?
Lord Justice Underhill says the leading judgment was given by Lord Justice Sedley who agreed with us. Do you see that penultimate line in paragraph 22? Before the first quotation. Second point, paragraph 23. It appears to have been the case that sub-tribunals have read Cougar thus as establishing a rebuttable presumption against any relationship between adult, child and parents. Third point, the Upper Tribunal in Gissing was one of the cases which Mr. Toman, King's Counsel, cited to the first tier below. In Gissing, the tribunal was critical of that reading. It observed that the judgment in Cougar House has been interpreted too restrictively in the past. It ought to be read in light of subsequent decisions of the domestic and Strasbourg courts. That's the third point. The fourth point is, you'll see that Lord Justice Underhill sets out in full the account of the Strasbourg case law, and you'll see there that there are many cases there which do not apply the strict, high, rigorous, we say over-rigorous test, which Sir James urges upon you. And at paragraph 47, they say, the Upper Tribunal says, that there are cases which have lost. What they draw from that, my fifth point, is at the penultimate paragraph on the page, 414, if you have that. The different outcomes in cases with superficially similar features emphasises to us that the issue under Article 8.1 is highly fact sensitive. And then the sixth point over the page, this decision was approved by Lord Justice Dyson in Gurung. We've got Gurung. I wasn't going to take you to it. I can just give you the references if you'd like to see it. The reference to Gurung is tab 14, page 277, and the endorsement of Gissing is at 298. These are all Gurkha cases. So P.T. Sri Lanka isn't, but Gissing and Gurung is. And the case I'm going to come to is another Gurkha case. And seventh point, so Singh, we thought about producing Singh. It's one of the cases you haven't got, but didn't think we needed to. It's important both because of what is extracted there by Lord Justice Underhill from Lord Justice Stanley Burnton, but also because this is one of the cases before Lady Justice Carr in Mabini. So, seventh point, Singh Lord Justice Stanley Burns, he says, no difficulty in determining the correct approach. Adults, context of immigration control, no legal or factual presumption as to the existence or absence of family life. The approach of the European Commission cited in Kugathas didn't include any requirement.
It's incredibly unhelpful, that passage, finishing as it does, by saying a young adult living with his parents may well not, living independently, may not have a family life. Well, yeah, whatever. I mean, you know, how does that help us?
Well, you know that you don't. The test you apply is: are there further elements of dependence or real, effective, committed ties? And what you don't do.
Your case is that the test is further elements of dependency involving more than the normal emotional ties.
Yes. Yes, and no
I'm not sure.
exceptionality.
I'm not sure whether Sir James disagrees with that.
Well, I don't think he kept saying that you need true, strict
Well, he says that
dependency.
he says the further elements of dependency involving more than normal emotional ties, taken from the cases culminating in Kumari, shows that it's quite a stiff test.
Except that the survey here in Gizing shows that in other contexts it's not.
Well, just show me the cases. I'm afraid I couldn't read all those cases that were cited in paragraph 23 of Lord Justice Underhill. So show me your best one there that shows it's not a stiff test.
All I need to show, sorry, if I'll answer you this way. None of these cases apply a test of, are you incapacitated to the point that you're compelled to rely on the sponsor, or, as Sir James would put it, a test of true strict dependency. They apply the further elements of dependency test.
Well, somebody was sent to prison and he still had family life. A child who'd left home had family life.
None of these cases are about paraplegics or people with Down syndrome who are completely incapacitated and compelled to rely in their daily life on the sponsor. Mm-hmm. And the eighth point I was going to make, if I may, is that at paragraph 26, Lord Justice Underhill says that Lord Justice Sedley's statement of the applicable principles has not been in any sense disapproved, unsurprisingly, since it requires a fact-sensitive approach, but it's got to be understood in the light of the subsequent case law helpfully summarised in Gizing. So that's Lord Justice Underhill, with, at the end of the report, you'll see Mr. Justice Cranston and Lord Justice Beatson agreeing. Next case I wanted to take you to was Rye, in the next tab. So this is Lord Justice Lindblom. Sorry, thank you. Lord Justice Lindblom, Lord Justice Henderson, and Lord Justice Beatson. So this is a case which we'll see endorses Kugathas, Lord Justice Sedley, and the Patel case that I took you to. It's another Gurkha case. At paragraph 16, page 426, Lord Justice Lindblom says the legal principles are not controversial. He then cites at 17 Lord Justice Sedley. He then cites Lady Justice Arden. So I think this will be possibly a confused case. I think it's one of the confused, the court was confused here, apparently, it is said, because you've got both Lady Justice Arden, para 25, and Lord Justice Sedley, para 17 in Kugathas. And then at the end of that paragraph, he cites Patel, what may constitute extant family life falls well short of what constitutes dependency. And then he cites Gysin at paragraph 18, and the tribunal's observation in that case that Kugathas had been interpreted too restrictively in the past. And at paragraph 19, this is a passage I've already shown you. You just cast your eye on that. Paragraph 20 is the sin passage I've already shown you. And at paragraph 36, at 36, bottom of page 430, as Miss Patry for the Secretariat submitted, it was open to the tribunal judge to have regard to the appellant's dependence, both financial and emotional, on his parents. That's irrelevant, but the key concept, if we see over the page, is support. If, however, the concept to which the decision maker will generally need to pay attention is support, which means, we'll just steadily put it in Kugathas support, real, committed, effective. There was, it seems to me, ample and undisputed evidence on which the judge could have found, based on finding such support was present in the appellant's case. He found, however, the appellant had a reliance upon his parents for income. It doesn't place him in a particular unusual category, either within this country or internationally. No indication on balance of a dependency beyond normal ties and financial dependency. These findings, counsel submitted, suggest that he was looking not just for sufficient degree of financial and emotional dependence, but also for some extraordinary or exceptional feature in the appellant's dependence upon his parents as a necessary determinant. Counsel submitted this was too exacting, inappropriate, seems to reflect the earlier reference in the decision below to the requirement for some compelling or exceptional circumstances. Elevated the threshold of support that is real or committed or effective too high. Paragraph 37. These submissions have force. And Lord Justice Henderson agrees. Paragraph 59, page 435. Paragraph 60. Lord Justice Beatson gives a short judgment. Paragraph 61 underscores that there's no test of exceptionality. That's contrary to the approach in the Gysin cases approved by this court.
But as I read the judgment, the really important point which persuaded the court to allow the appeal was the absence of any references. So if you look at paragraphs 37 and following,
yes,
the Upper Tribunal's failure to take into account the circumstances in which the parents supposedly chose to leave the son and come to the UK.
Yes, but there's no semblance of incapacitation, compulsion to rely on the parents, complete dependency in the sense.
But this is because each case has to be looked at on its facts.
Yes.
And the key fact in this case was the circumstances in which the parents supposedly chose to leave the one remaining son.
Yes. So
in Nepal.
yeah. So if each case has got to be examined in light of its facts, proposition with which I of course agree, then there's no legal error. In our case, this decision is powerful support for the proposition that the tribunal did not go below. It applied the test, which you have seen by now. Multiple constitutions of this court said is good law, and it reached a decision which seems seems generous, given the illustrations, examples given in Kumari, but does not seem harsh, or, in our submission, so it does not seem generous when one looks at the domestic case law as it interpreted other Strasbourg cases. The moral is, don't get too hung up. So Andrew, the Vice-Chancellor, Sir Andrew Murray, don't travel around in the law reports looking for clues in the facts. This is not common law. Sorry?
Wasn't the Court of Appeal in Aston County overruled?
Not on. Thank you, my lady. I should have said that. Not on that point.
Okay.
I checked.
All right.
In which case?
Aston County, the ecclesiastical law case.
Well, you better send it to me because I
will.
got it.
I will. We've got Aston Canto in the bundle. If you want.
Have you? Where is it?
Yeah. If you want the phrase, it's an early case, so it's going to be. It's in fact number 1.
Aston Canto.
Right?
Yeah.
It's number 1, and it's page 17, paragraph 44. Very famous passage. Do you have it?
Yeah.
Our task is not to cast around in the European human rights reports like black letter lawyers seeking clues. In light of Section 2, it is to draw out the broad principles which animate the Convention. And the dangers of doing that are demonstrated by the authorities I've just shown you. We respectfully submit.
Well, I mean, I've just looked through the as best I can, the Upper Tribunal decision in this case.
Yes.
And it seems that they mention the, what one might call, additional elements test several times.
Yes.
And they say at paragraph 42, the general principles set out in Kumari reiterate what had gone before, been recognised and applied in the domestic authorities. They all boil down to the essential point that whether there are additional elements
Yes.
of dependency between adult members of the family is to be decided on a case-by-case basis.
That is the test.
You say that's correct?
That's correct. And there's no perversity challenge. So the question is, did they get that wrong? Our submission is, it's an ambitious submission to say they did. It involves sweeping away, as my lord put it, 2 decades of case law at this level. I haven't counted the number of judges who've applied it, said it's right, saw no distinction between Lady Justice Arden 25 and Lord Justice Sedley at 17, but it's in 2 digits at least. And that's before we get to precedent. So James
you say,
avoids...
I suppose you say Kumari dealt with some very difficult disability cases,
Yes.
very harsh disability cases, but I can't remember the name of it, Singh or ZB or Underhill. Lord Justice Underhill.
Yes, the Sri Lanka case.
summarised a lot of much less
Other
harsh
ones,
cases.
yes. PT Sri Lanka.
PT.
PT Sri Lanka, yes. And the idea, as Sir James put it yesterday, that you've got to have a medical condition to be in the foothills. That's what he said. It is a very austere, his approach is a very austere and reductive approach to what is supposed to be a holistic, intensely fact-sensitive inquiry, live evidence very important, to evaluate the strength of ties and further elements of dependency. And then I want to take you please to the Udin case. So this is important. So James can avoid the precedential impact of the cases I've just taken you to by saying, oh, they are confused. All these judges were confused because they shouldn't have cited Lady Justice Arden and Lord Justice Sedley. But he can't say that about Udine in our respectful submission, although he treated this as another confused case. Udine is at paragraph 20, tab 24, page 499. So the case concerns, if you just cast your eye over the head note, the case concerns a child, a foster child attaining majority and claiming family life with his foster family. So this is Lord Justice Ryder, as he then was, with whom Lady Justice King, who would know something in this area again, and Lord Justice Bean both agree. At paragraph 12, the FTT directed itself, let us see, in accordance with Lord Justice Sedley in Kugathas, which was itself a citation in the European Commission. Dependency not limited to economic. At paragraphs 26 to 30, Lord Justice Ryder sets out Kugathas, this is page 506. And then at 31, page 507, he says, dependency in the Kugathas sense is accordingly not a term of art.
So which page?
Page 507, paragraph 31.
Yeah, got it, thank you.
Dependency in the Kugathas sense is accordingly not a term of art, it's a question of fact, a matter of substance, not form. The irreducible minimum of what family life implies remains that which Lord Justice Sedley described as being whether support is real, effective or committed. Subsequent case law has built but not detracted from Kugathas. Then Gizing is cited in that important decision of Mrs. Justice Laing and Upper Tribunal Judge Jordan. Consider the authority since Kugathas, observe that family life between adult children and birth parents will readily be found without evidence of exceptional dependence. Insofar as it's been suggested Kugathas had ever described a rigid test of exceptional dependency, this was dispelled. I respectfully agree with their conclusion that each case is fact sensitive. Paragraph 34, Secretary of State goes further, submits foster care is a special category incumbent upon an applicant to prove family life in a way that would otherwise be presumed in a birth family. I can find no support for this proposition. The principles in Kugathas described in the judgments to which I've referred are of general application. So there's a deprecation there of the idea that you've got your core family and you've got to approximate everything to that. The family life that is presented before the court, that is what requires respect and protection. No predetermined models, Lord Bingham. And then at 36, the existence of family life after a young person has achieved majority is a question of fact. No presumption, either positive or negative, for Article 8 purposes. And then, paragraph 40, this is key. 40, Roman 1 is key. The following principles can be described from the authorities. So here, he's deriving principles, as I think the Justice used often to do, certainly as Master of the Rolls. following principles can be described. The test for the establishment of Article 8 family life in the Kugathar's sense is one of effective, real or committed support. There is no requirement to prove exceptional dependency. So there's no, he's not applying Lady Justice Arden dependency here, so it can't be a confused case. And he
But that's contrary to what your submission is.
Sorry?
That's contrary to your submission, because your submission is that it's additional elements of dependency in addition to emotional ties.
Assume Sir James is right, and there is clear blue water between Lord Justice Sedley at 17 in Kugatas and Lady Justice Arden at 25. Assume that's right. Lord Justice Ryder.
I mean, the problem is effective, real or committed support on any real analysis is not the same as additional elements of dependency.
Well, you interpret the phrase in those terms, and I've shown you at over length, I'm sorry about that, that's not the view of the courts. And Lord Justice Ryder here applies the test of effective, real or committed support. So Sir James has got a precedential problem here. This binds you.
Well,
it's part of the ratio, because if we carry on, you'll see that's the test that's applied.
mm-hmm.
So this is binding. Mobeen isn't the only case that's binding. Of course, if I'm right, then all the other cases are binding as well. So I'm assuming the worst case on the Kugasaf reading against me. I'm assuming there's clear blue water between 17 of Kugathas and 25 of Kugathas, even though Lady Justice Arden doesn't say so, and even though many, many, many judges think that they're saying the same thing, two sides of the coin. You've got to understand what she says in that one sentence, in light of the fact that in the preceding clause she cited SV UK. But assume all of that's wrong. And she had a profound disagreement with Lord Justice Sedley, despite not saying that. What's the answer to Udine? And what's the answer to Mobeen? This is ratio. It binds you.
well, we know it's AB, and we know the answer Sir James gives. If it's binding authority, he says the Court of Human Rights has moved on.
Well, that's a free two. That's the RJN case, I think. AB is fully confident.
Sorry, yeah. Well, yeah.
And we say that applies to principles.
Mm-hmm.
In that case, the argument was that the solitary confinement of a young person was ipso facto contrary to Article 3. And if you remember...
Which is it? RJM is the one...
The free two.
The what? Free two.
Yeah,
free two.
Free two is RJM. Fully confident is AB.
Okay.
But AB, our submission is that in the passage I asked, the context is, if you want to look at context for the observations that are made, context is paragraph 53 of AB. The principle that solitary confinement ipso facto is violation of a child, is ipso violation of Article 3, would have been a major departure from the principles currently laid down in the Convention jurisprudence. It's the principles that you've got to find. We've got them. There's no departure, and you've got my submissions about the case law. But his first submission is Kugathas, Komari, clear and constant, look backwards and look forwards. His secondary submission is it's a new dawn, a new austere dawn. And my submission there, I'm sorry, I probably didn't finish it, is that that's not clear and consistent. You've got single chamber, same single chamber, apparently saying something that's prima facie at odds with it in Alvarado, paragraph 49, and then you've got second section, single chamber again. And RJN, the free to, remember I invited Sir James to take you to a passage again, he was very kind, he did it. Lord Neuberger says that you should be less prepared to depart from binding authority on the basis of a supposed change in Strasbourg where it's not Grand Chamber.
Which case was that?
RJM, tab Thank you, James. It's tab 8, and the passages are, if you remember, stare decisis, paragraph 66, page 156, Young and Bristol, and then 67 I invited Sir James to get you to read, and at 67 Lord Neuberger accepts, particularly in relation to decisions which are not of the Grand Chamber, the Court of Appeal may be less ready to depart.
Yeah.
And I would make the obvious submission that you'd need something pretty dramatic in Strasbourg to, as you put it, sweep away this massive case law. The next case I wanted to take you to is a case you may recall, you were in it, my lord. It was Lord Justice Warby who gave the judgment. Again, Lady Justice King and yourself who agreed. This is Saliu. And Saliu is at tab 25, page 510, thank you. This was a weak case on its facts. My lady had granted permission to appeal. We see that at paragraph 15 to 16, by potentially applying too narrow a test of exceptional circumstances. It was, if I may say so, a weak case. The findings in the tribunal were that the evidence had been contrived. But for present purposes, it's enough to say that at paragraph 32, Lord Justice Warby endorsed Kugathus and PT. PT is that case, Lord Justice Underhill, the review, as leading cases. That's page 519 at the top of the page. Principles well established, set out in the leading cases, Kugathus, Singh, that's the passage you didn't find very helpful. That's the so what Singh. And then PT Sri Lanka, that's Lord Justice Underhill. Key points, when it comes to adult family members, no legal or factual presumption as to the existence or absence of family life. Not enough that there is love and affection, has to be something more. Irreducible minimum is real, committed or effective support. Careful examination of facts is called for. No suggestion that those principles were ignored. So that's Saliu. And then we finally come to Nabeen. Sorry, it's such a long run-up. And Nabeen is at tab 26. The next tab. And you were taken to 44 to 50. I actually just take it very shortly and just. I should make the point that the issue of, I think Sir James said that the court here didn't look at the Strasbourg. I'm completely lost. I'm so sorry. I'm in the wrong tab. Sorry. Apologies. Yes, Sir James said that it wasn't clear that any of the Strasbourg cases had been looked at. But if you look at 44, citing cases which interpret Strasbourg authorities at length. So Kugathas Singh 1, she calls it, that's the Mr. Justice Mundy case I took you to, Lord Justice Dyson. ZB Pakistan I've taken you to. Singh 2 is the Lord Justice Stanley Burnton one. Britsits we haven't got, we don't need it. AU, important, AU is Udine, the case I just showed you, or I showed you last but one. And
Justice Ryder.
sorry?
Lord Justice Ryder's one.
Exactly,
Yeah.
the foster care. Yeah. And then 45, whether or not family life exists is fact sensitive, requires a careful assessment of all the relevant facts in the round. It's important not to be overly prescriptive as to what is required. Comparison with the outcomes on the fact in different cases is unlikely to be of any material assistance, and we respectfully agree. That is said, in 2021, Sir Andrew Morritt had said it in 2002.
So what did he say?
That's the black letter lawyers don't scrabble around looking for clues.
Oh, she cited that, did she?
No. I'm saying she's effectively saying the same thing. With your lordship's very fine analysis, maybe it's not, but it's cognate with that.
Which paragraph?
45.
45.
Important not to be overly prescriptive as to what's required.
Yeah, I see. Yeah.
Comparison with outcomes on the facts in different cases is unlikely to be of any material assistance. Cognate with Sir Andrew Morritt, Vice Chancellor, at paragraph 44 of Aston Cantlow, tab 1 of the
Can I just, while
Yes.
we're on that point,
Of course.
deal with you submitted that the appellant's challenge in this case was to the test only.
Yes.
I mean, the ground, looking at they had 5 original grounds, but if you look at paragraph 10 of their skeleton, they're saying that on a correct application of the law, there was no family life or interference with family life, which appeared to be the sort of could or should, as it was originally expressed in the grounds of appeal. Are you saying that this is only a challenge in relation to the legal test rather than...
That's how I'd understood it.
Right.
If Sir James is accepting that the legal test is as Kugathas sets out, which would be a surprise to me, and insofar as he's suggesting that that is that was perversely applied, we're in error of law territory, not wrong, was perversely applied, we would resist that, but we haven't detected that submission.
Okay, thank you.
And then 46, case law establishes that love and affection between family members are not themselves sufficient, there has to be something more. Normal emotional ties will not usually be enough. Further elements of emotional and financial dependency are necessary. No requirement to prove exceptional dependency. Formal relationships between parties will be relevant. Ultimately, it's the substance, not the form, that matters. Existence of effective real community support is an indicator. Your lordship alighted on that. That's, with great respect, is slightly loose language because of the following paragraph.
Yep.
Cohabitation is generally a strong pointer. Extent of nature of any support from other family members will be relevant, as will the existence of any relevant cultural or social traditions. In case of the focus on the parent, the issue is the extent of dependency in the broad sense, we submit, of the older relative on the younger ones. And whether that dependency in the broad sense, we submit, creates something more than the normal emotional ties. Again, Lady Justice Carr looking at dependency in that broader sense. And then this is absolutely key. The ultimate question has been described as whether or not this is a case of effective real community support. See Udine at 40, that's where Lord Justice Ryder collects the principles and says no exception.
She's just commenting that how it's been described.
Sorry.
On one analysis.
Sorry, I've
On one analysis, she may just be commenting that that's how it's been described.
Oh, I see
in
what
those
you mean.
cases.
yeah,
I mean,
you've got to read this.
doing the best we can, she seems not to be trying to say anything new in this case.
Okay, so I can rest on Udin for my stare decisis point.
Rest on Udin.
Udin for stare decisis. Assume
And Lord Justice Ryder's sort of summary of principles.
exactly para 41.
Well, you can't rest on that if you submit that the proper test is additional elements of dependency. I mean,
as interpreted in Kugathas to mean real and effective or effective support.
well, then she does say that the existence of effective real or committed support is an indicator.
In 46, at 47, she says the ultimate question has been described. She's not making a passing comment and saying that's how it was described historically, and I've changed. I think it's wrong. She's not saying that. It's just a summary.
But is the summary in paragraph 47 consistent with the points that are made in 46, or is it an accurate summary of the points made in 46?
I would say that the word indicator, read literally, is slightly loose with the very greatest respect, because that's the test. Because she says the ultimate question has been described as. Now, I take my Lord's point that it's not a tax statute. Has been described as being whether or not this is a case of effective real or committed support.
I mean, not only do you have to be careful about reading European Court of Human Rights decisions as deeds and not ferreting around for them, you have to be careful in an area where the Court of Appeal has been faced with thousands of immigration decisions over the last 30 years of construing judgments which deal with what is undoubtedly a factual exercise as stating the law. Now, I completely understand that Udin does purport to state the law, but it purports to state the law in a way that does not seem to chime with the European Court of Human Rights' repeated formulation.
Only if you think that...
If they're different.
Lord Justice Sedley at 17 is wrong. And my submission is...
Whether he's wrong or not, if they're different, I mean, if it's the same, it doesn't matter.
My submission is you've got my submission about two sides of the same coin.
Don't we have to read the statements, the broad statements in Udin, against the actual issue in that case, which is pithily summarised by Lord Justice Ryder, as it then was in paragraph 41. The applicant was an orphaned young man abandoned on the streets along the age of 13 with no known family. He was brought up and cared for by a foster family,
yes,
and so on and so forth.
So
and he's still in the UK, and
Right.
pathway plan and all the rest of it.
Right.
So this is the facts. You might have
Right.
dictated the answer. But
if my lady is putting to me that the words in paragraph 40 at page 508 in Udin, I quote, accordingly, the following principles can be described from the authorities. 1, the test for establishment of Article 8, family life, in the Kugathas sense, is one of effective real or committed support. There is no requirement to prove exceptional dependency.
But
if my lady...
ratio of the case
Yes.
is not in... I mean, this is why I always say extrajudicially that it can be dangerous to state principles from authorities as if they are the ratio of the case you're deciding. They may or may not be. If you state them wrongly or incompletely, there is a real danger, because what happens is cases, as my lady repeatedly points out, are decided on their facts, and the ratio of them depends on their facts and what they actually decided. If you state principles too broadly or loosely, then we're not bound by those statement of principles if it turns out they're, as I say, not complete or too loose. And it does look as if Udin may be such a situation, because it doesn't accord with many other authorities which do seem to talk about the need for additional elements of dependency, which is your own submission.
It is, because I say there's nothing different. It's two
And
sides.
indeed, it's not only your own submission, it's what the UT decided in this case, a decision which you're defending.
Yes, because they think it's the same thing.
Sorry, they think
They
it's
think
the same
that,
thing
that
as what?
Lord Justice Sedley's formulation is the same as the SVUK formulation. So the support.
No, they criticised the part of the judgment in the UT where they said that it is lower than dependency. I can't remember the paragraph, and it's sort of
Yes.
one, I can't remember which.
Yes.
25?
Yes, yes. My submission is that this is the other side of the coin. Sorry if I haven't made that clear. It was one of the early things,
No, you have made that.
the early things I said.
Yeah.
And by way of background, the context is that the judge below, so the FTT judge, if you look at paragraph 12, had referred to both Kugathos. Sorry, I'm so sorry. Lord Justice Ryder says that she appropriately relied on the principle most often cited from Lord Justice Sedley in Kugathos, which was itself a citation from the European Commission of Human Rights in Essen, UK. Now, it's not a citation, it's an interpretation, but my point is that Lord Justice Ryder had well in mind that Kugathos is interpreting S. And he says that he says that that is the test. In terms, that is the test for establishment. There's no requirement to prove exceptional dependency. And I resist, with great respect, the idea that when it's applied in the disposing paragraph, in paragraph 41, the next paragraph, that that deprives it or restricts it, restricts its precedential value to the fact situation that was before the court in that case.
Can I just ask you one bit of the test in 40 subsection 2 of Lord Justice Ryder?
Yes.
Is he right to say the test for family life within the foster care context is no different to that of birth families? The reason I ask that is because my understanding or misunderstanding is that there's a presumption in birth families.
You're right.
So I mean, it may have been an attempt to be helpful, and it may be better to see this as just carrying on S and being both sides of the same coin, because that, I'm not sure, is an accurate statement.
It's not.
No.
You're absolutely right, but we don't rely on it.
No, you're not relying on that bit. But if we're trying to assess it all, I thought I'd better ask you about it.
Except that what he's got wrong there, with great respect, is that birth families, there's a presumption of family life. So it's an error that's totally immaterial to relevance.
I understand that. It's just if one's looking at propositions of law, then actually as a proposition of law, it's not right. But in fact, it made no difference.
It makes no difference there, actually. It makes a difference as a proposition of law, because he's undercounted, if you like, birth families. By analogising foster care context to birth families, he's done birth families down.
Exactly.
And the case isn't about birth families.
Yeah.
So it's immaterial. But that if that somehow bleeds into one, we resist that. If the idea that bleeds into one, well, no, there's nothing wrong with one. We respectfully submit.
Thank you.
And then, I'm very grateful to Mr. Fakori that at 41, what is said is that it may be significant that through the support that's provided, so that's the basis for allowing the appeal and remitting. Just above letter C. So those are my submissions as a matter of law on these cases. There's something I need to address about the so-called by association or by extension point. So this is, sorry, that's probably very telescoped. This is the idea. It's quite prominent in Sir James's submissions and something upon which my lady alighted. This is the idea that what happened here, the findings were that the family life that was enjoyed was between brothers, sponsor and A1, and then the rest of the family life with the sponsor was by way of a deeming rule because of the unitary nature of family life. And Sir James suggested that this is how it had been put before the First Tier Tribunal. I accept that that's how, at first instance, it appears at the first look. It's in fact not.
Well, hang on. Are you addressing ground 2 now?
No, not yet. I'm just finishing off on ground 1, family life. The existence of family life. And what I'm meeting is the idea that you can deem, it's not a separate ground of appeal, but it's featured quite prominently in Sir James's submissions in his skeleton, and my lady, I think, was, if I may say so, rightly exercised by it.
Right.
We do not accept.
What is it? Yeah.
That you can have a relationship between the sponsor and the first appellant, and because the first appellant has his nuclear family, automatically there is a family link between the sponsor and the other appellants. But that's actually not how the case was put. That's the error made by, it's an immaterial error we submit, made by the first tier. Does that make sense? Maybe it's better if I actually show you a passage which Sir James took you to very early on. He took you to paragraph 7, and it's at page 140.
Paragraph 7 of FTT.
I'm so sorry. FTT 140, 41.
Yes. Family life by association.
Yes, exactly. And it is said that, well, that's not actually what was said. We'll see in a minute. Because if you look further on, when the findings are being made, if you look at paragraph 21 at page 142, in this case, it said the sponsor and the first appellant were particularly close as children. It's accepted they've not seen each other for 17 years. Sponsor hasn't felt it was safe to return to Gaza. So very different from what was going on in Kulitas. It said that for the vast majority at the time, any support was emotional only, as the first appellant was working and providing for his family, didn't need financial support. I accept that the sponsor and the first appellant are close, and this is the important clause, sorry I've taken time getting there, and that the sponsor has a close relationship with his brother's wife and his children, albeit one formed at a distance. And indeed that is how Mr. Kiriko had put the point. So then when you come to the finding at 26, it's based upon considering the evidence in the round, as you'd expect, but it's the framing, sorry, I've skipped a paragraph, it's the framing by the tribunal at 22 that creates the issue. The tribunals say, I find the response references to the fact there's clearly family life between the appellants and other siblings and their parents and siblings outside the country, not of particular relevance, as the question is in reference to the relationship between sponsor and A1 and the remainder of the appellants given the unitary nature. So the way it's put is there is a real relationship between wife and kids. The way the tribunal frame it is to say, oh, you don't have to worry about wife and kids because of some sort of deeming provision. That's loose language again, I'm sorry.
So what do you say about that? There is no
We say that that's not how the case was put. And in fact, when you look at 26, you should interpret 26 as a finding that in fact there was family life between the sponsor and all the appellants. Because the opening words of 26 are, you consider the evidence in the round. And the next clause is, there's a family life between the sponsor and the appellant, first appellant, sorry, in particular. And it's the by extension bit that I think is loose, I submit is loose phrasing in the tribunal's terminology. And the error comes from its own framing in paragraph 22, which is not what the case was about. How the case had been put, sorry, which we see at 21. And then if I just give you references, I can show you Mr. Kiriko's skeleton.
But why do we need to look at the skeleton? I mean,
Because the case,
I thought we were dealing with an appeal from the Upper Tribunal, which had decided there was family life.
Yes, and I am probably unnecessarily, through an abundance of caution, trying to meet the case, which Sir James has trailed in all submissions. It doesn't form ground of appeal, but you've got my submissions.
Okay.
So I can make a start. Those are my submissions of ground one, unless you have any questions for me.
No, so you go on to ground 2.
And I can make a start now, or would
Yes,
you like?
of course you can. Can you just tell me the answer to this question? Is ground 2 relevant to ground 1 at all?
No. We accept Sir James's submission. In fact, it leads on to an interesting point. Sir James accepts that, assume I'm wrong on ground 2, and the only rights holder is the sponsor. What follows? Does it follow that you only look at family life from the perspective of the sponsor? Answer, no.
Answer to what?
Do you consider the ties, the support, additional elements of dependency only from the sponsor's perspective? We're in the stage of Article 8.1, family life. You put that question, my lord, to Sir James, and he said no. You look at it from both perspectives. He was, with respect, right to say that, because do you remember in Kumari, the mother is in India, the court looks at the question of ties.
So before you come to Kamari, what I've written down is that you accept that if you're wrong on ground 2 and the sponsor only has Article 8 rights,
yes,
you still do not consider family life under Article 8.1 only from the perspective of the sponsor.
that's exactly my submission.
Yes. Okay.
And Sir James, in answer to you,
So James agreed with that.
agreed with that, and he fairly and rightly gave the reason that in Kamari, the mother is in India, and yet when the court considers the H1 question, is their family life, they consider both. From the son's point of view, the son's in Netherlands, the page references are 1706 to 7, paragraphs 46 to 48, son, 49 to 52, a mother.
Right.
So you look at, so it doesn't make a difference on ground one.
On ground 2, it does matter because you would not then consider in the proportionality exercise that the residents outside the jurisdiction themselves had Article 8 rights that needed to be protected by the state.
Yes, and that's, we submit, if I'm wrong, I mean, you could bifurcate ground 2.
Once there's family life, then you only consider Article 8 once you've got family life.
Yes, but if we bifurcate ground 2, ground 2A is that no one is a rights holder other than the sponsor. Ground 2B is, so what? Our response is, so what? Doesn't make any difference at all. And I'm going to press that submission, press both submissions, that properly understood, the Grand Chamber absolutely is saying that jurisdictional link establishes the people abroad as rights holders. Why would you even refer to a jurisdictional link if your sole concern is with the individual here? You don't need a jurisdictional link, they're in the territory. And if you look at the cases they endorse, in particular Nessa, there's a case they endorse in the Grand Chamber, it's very clear that they're endorsing the proposition, this is a special case. It does not involve extraterritoriality, as they put it, even though, as they put it, there's an international dimension. And so we say that the case law strongly supports our submission on 2A, that the rights holder in this context is not limited to the people in the territory.
Well, you surely do accept that the family in Gaza don't have Article 2
Of course.
or
Of course
Article
they
3 rights.
No, of course not. No, not for a moment. But there are other cases which Sir James didn't take you to. I'm going to take you to. There's a case called Ali, which explains Abbas in the context of private life. It's a very unusual case, but it's a case where both adults are outside. They previously were in the UK, and the Court of Appeal says that they are both rights holders. They're both outside. And what's the link? It's the private life that they had before. It uses the term jurisdictional link. Sorry, one adult is outside. Yes, it's just one adult who's outside. But there's nobody here. His jurisdictional link with the UK is the fact that...
That case, if I happen to remember that case, that's a slightly different situation because they'd been here and acquired rights
Yes.
and then left.
Yes.
But there's no acquisition of Article 8 rights. There's no acquisition of rights by territorial location in any of the 6 appellants.
Not territorial, no, but your lordship's aware that the Article 1 used to read, residents in the territory, all states shall secure rights to people who are resident in the territory. That was rejected in the drafting stage. It's been too narrow. There's jurisdiction. It doesn't matter that they claim the territorial jurisdiction. What they've got is a link, a jurisdictional link. And I keep come back to the point, I'm sorry if I'm labouring it. Why on earth would the Grand Chamber talk about a jurisdictional link if it's only thinking about the people who are here? It doesn't make any sense at all.
Okay, well, I think we're going to come back to that at 2 o'clock, Mr.
And 2B doesn't make any difference.
So what?
So what?
I
Because
understand that.
you look at all the circumstances and the impact on the family.
Okay. How are you doing for time? How are you doing for time?
Well,
How long are you going to give Sir James to reply?
yes, well, I think I was fairly sort of not indulgent, but I didn't create too much.
No, but he's still going to have a chance to reply.
No, of course.
Now, how long are you planning
do your
to leave
lordship? Can you? What time can you sit until, my lord?
4:15.
4:15. Can we have a discussion? Or no, you don't want a discussion. I would like to go until, given that the agreement that we have.
I would say 3:45 is the limit.
I was going to say.
Okay, we'll set it 2. Thank you.
You.